Can a nonprofit organization own an LLC? This question often arises when exploring the intersection of business structures and charitable organizations. While an LLC itself cannot be a nonprofit can indeed own an LLC as a subsidiary. This arrangement offers unique advantages and requires careful navigation of legal and tax considerations. Let's start by clarifying why an LLC cannot be a nonprofit. Limited liability companies, or LLCs, are designed to provide tax flexibility and personal liability protection to their owners. However, they are not eligible for tax-exempt status because of the tax options given to owners to pass through revenues. This fundamental characteristic conflicts with the nonprofit model. On the other hand, a nonprofit organization can own an LLC as a subsidiary. This structure is particularly useful for nonprofits looking to separate certain activities or manage potential risks. A single-member LLC, wholly owned by a nonprofit, is treated as a disregarded entity for tax purposes. This means the nonprofit can report the LLC's financial activities on its own tax return, simplifying the process while still maintaining liability protection. Why would a nonprofit want to create an LLC subsidiary? There are several compelling reasons. First, it can help protect the parent nonprofit from potential liabilities associated with specific activities or property ownership. For example, if a nonprofit receives a real estate donation with possible environmental liabilities, placing it in an LLC subsidiary can shield the parent organization from future obligations. Additionally, LLC subsidiaries can be used to manage income-generating activities that support the nonprofit's mission. This separation can be beneficial for financial management and risk mitigation. It's also useful for joint ventures with other organizations or for conducting high-risk activities like medical research or housing initiatives. However, nonprofits must be cautious when using LLC subsidiaries. The IRS closely monitors these arrangements to ensure they don't jeopardize the nonprofit's tax-exempt status. The LLC must avoid excessive unrelated business income, or UBI, and steer clear of political activities or lobbying. Passive income, such as rental property income, is generally not considered UBI and can be a safe avenue for LLC activities. To maintain compliance, nonprofits should follow several key guidelines when operating an LLC subsidiary. First, maintain strict legal and operational separation between the parent nonprofit and the LLC. This includes having separate boards of directors, keeping distinct financial records, and ideally, employing separate staff for each entity. Transparency with the IRS is crucial. Nonprofits should report the LLC's activities on their information returns, such as Form 990. They should also ensure that any transactions between the nonprofit and the LLC are at fair market value and properly documented. The LLC's operating agreement should explicitly state that its activities support the mission of the nonprofit and adhere to IRS nonprofit regulations. This alignment is essential for maintaining the tax-exempt status of the parent organization. In conclusion, while an LLC cannot be a nonprofit can strategically use an LLC subsidiary to manage risks, separate certain activities, and protect assets. This structure offers flexibility and protection, but it requires careful adherence to IRS guidelines and a clear focus on supporting the nonprofit's charitable mission. By understanding and following these principles, nonprofits can effectively leverage LLC subsidiaries to enhance their operations and further their goals.